the waters of the DA. Soon thereafter, we received a follow-up complaint from the minister himself requesting that we need to investigate him. And on the 2nd of May 2019, the report was dispatched to the minister and the complainant, Mr. Walters, the complainant, and to the President of the Republic, Mr. Cyril Ramaphosa, with the effective date being 3 May 2019. My office received an acknowledgement of receipt of this report by the President shortly after 5 on the 3rd of May 2019. Later that afternoon, the Minister approached the North Gauteng High Court with a view to secure an interdict preventing me from releasing the report and also stopping the President from acting on the report. In his court papers, the Minister acknowledged the receipt of the report, which was delivered to his office on the 2nd of May. Simultaneously with the delivery of the report, the Minister was favored with a copy of a letter to which the above stated acknowledgement relates, and it was addressed to, enclosing the letter from the President. The agent application by the Minister for granting of the interdict was arranged to be heard at an agent court from 6 o'clock p.m. as soon thereafter the parties may be heard. Despite the aforementioned factual exposition, the interim interdict was granted. As a result, I'm precluded from publishing the report. I must, however, here demystify the illusion that Minister Nkwinti was never afforded an opportunity to respond to a Section 79 notice, a notice we issue to implicated parties, and our rules, Rule 24(2)D of the Public Protector relating to investigations. They were published in the Government Gazette in 2018. Minister Nkwinti had 10 days within which to respond to my Section 79 notice. I had, however, in terms of Section 79 notice, afforded the Minister effectively 18 days to respond, which was 8 days more than what the rules provided. The Minister received the notice on the 2nd of April, with 20 April being the date to respond, but it was only on the 16th of April, 14 days thereafter, where the Minister requested an extension, citing reasons of party political commitments relating to the elections. Later on, the Minister sent another extension requesting postponement, citing too many forthcoming holidays. Both these requests did not persuade me to sound reasons upon which the extension could be granted. So it was curious of me to note that 14 days thereafter, the extension was requested, 10 days, which in fact beyond the 10 days which is required by the rules. So again, I'll proceed then to issue the following reports. Let me now deal with the reports or the finding which I'm free to reveal to the public. I will start with the case of Kema and others versus Gauteng Provincial Government. I received 3 complainants in which maladministration and improper conduct were alleged in connection with the MOU entered into between Gauteng Provincial Government and the Gauteng horse racing industry in 1997, which subsequently led to the corporatization of the horse racing industry in South Africa. The first complaint was lodged by Ms. Kema, 22 January 2012, who at material times had to, and in lodging the complaint, was representing a company called Africa Race Group that was involved in race horses breeding. The second complaint was lodged by Mr. Simoto, 16 April 2012, who was at all material times lodging the complaint on behalf of 4,000 members affiliated with the South African Grooms Association. The third complaint was lodged by Mr. Hanif Manju, a former member of the Gauteng Gambling Board's Horse Racing Committee. This was lodged in 2013. I found that the allegations that Mr. Leketi did not have the requisite authority from the Gauteng provincial government to enter into discussions and negotiations for the corporatization of the horse racing industry it was not substantiated because this matter was discussed at the provincial legislature. And as well that he failed to invite the public to participate in this process. This also is not substantiated. I further found that public funds were allocated from the Horse Racing Development Fund during the corporatization process for the upgrading of stabling facilities and for the construction of single and merit quarters for the benefit of the grooms at the New Market Racecourse. In addition, I found that the allocation to the land on which the Allington and Bloemfontein racecourses are located were owned by municipalities and or government at the time of the transfer to Mpumalanga. That was also not substantiated. Regarding the remedial action I have made, the following directives were to the President to take urgent and appropriate steps to take note of the report and constitute a ministerial committee under the stewardship of the Minister responsible for trade and industry that will be tasked with the duty to establish a statutory and independent body that will serve as a regulator for thoroughbred horse racing in the Republic. The President must also consider that the committee be constituted of ministers responsible for labor, agriculture, forestry and fisheries, human settlement, as well as sports and recreation. The Minister of Trade and Industry must take urgent and appropriate steps to lead the process of establishment of statutory and independent body that will serve as a regulator. The Minister must also take urgent steps and appropriate steps to establish a secretariat to this ministerial committee composed of legally qualified officials, accountants and people with knowledge in this industry. The Minister must embark on a consultation process with all industry players and stakeholders involved in the horse racing industry in the Republic with a view to making a determination on how they prefer that horse racing be managed going forward so that the sport could be taken back to its initial custodians, the people. Should a need arise, the ministerial committee appointed by the President to embark on a benchmarking exercise to learn best practices on in this industry. Minister of Sports and Recreation must take urgent and appropriate steps to, must take cognizance of the report and ensure transformation in this industry and expedite that particular process and ensure that sporting side of the industry is properly regulated. The Premier of Gauteng and other provincial premiers take cognizance of the report and ensure that the ministerial committee appointed by the President is provided with the necessary support to enable it to achieve its objectives. They must also ensure the statutory body that is established is capacitated to perform its functions independently without fear or favor or prejudice. The Premier must ensure that the 50% bookmakers levy, which was paid to Mpumalanga Gaming and Leisure, is withdrawn and transferred to the new entity that will serve as a regulator for this industry, for its operations as well as the development and transformation of the horse racing industry, and also assist in looking into new beneficial funding model. With the assistance of the SIU, the Premier whose provinces were affected by the corporatization of this horse racing industry must request the President to issue a proclamation in terms of Section 2.1 of the SIU to investigate the unlawful appropriation or expenditure of public money or property, unlawful or irregular, unapproved acquisitive acts, transactions, measures or practices, intentional or negligent loss of public money by state organ referred to in this report. The Gauteng Premier must extend an apology to the complainants for the inconvenience and frustrations experienced as a consequence of this conduct. The government, in fact, the CEO of the board of directors of the gambling board, to take urgent step to or to take cognizance of the report in consultation with newly appointed regulator, and to conduct an audit of all state-owned assets which were transferred to Mpumalanga for a song with a view to establishing their origin value and transfer and ownership of the property prior to the transfer, so that this can benefit the citizens. They must also ensure that 50% of the bookmakers which is paid to Mpumalanga, the board should withdraw this and transfer this to the new entity. Lastly, they must recover from Mpumalanga the balance of the funds which were earmarked for the erection of the and the married quarters for the benefit of the grooms in the province, Gauteng province, and ensure that a trust is established for grooms and other low-skilled employees in the horse racing industry. The second report relates to Matsena versus City of Tshwane, where we received a complaint from the caucus leader of the opposition party in Tshwane, the ANC, about the alleged maladministration, abuse of power, fraud, irregular appointment, and corruption by the Democratic Alliance-led municipality and Executive Mayor Msimang. He stated that in a brief period of 2 months, the city lied to the residents and committed various acts of maladministration, the consequence of which was fraud and corruption. The complainant also alleged that some officials were irregularly appointed in violation of the staffing policy of the City of Tshwane, and those officials were Marietta Okamp, the Chief of Staff, Mr. Samgelo Mkhwebane, the Executive Head and Mayoral Spokesperson, Mr. Stefan de Villiers, the Executive Head of the Executive Mayor, Mr. Matthew Gestner, the Acting Mayoral Spokesperson, Mr. D. Selani Babane, Strategic Executive Head. So those were the allegations. Again, that the allegation that the Executive Mayor or the former Executive Mayor issued a public announcement banning the use of blue lights with sirens around the city, deliberately and willfully misled the public regarding the constitution and the subsequent reconstitution of the mayoral committee, misled the public by stating that the previous mayoral committee had taken a decision to purchase a new fleet of BMWs for its members, announced that he will acquire a cheaper official vehicle other than the former executive mayor. Having studied the complaint, I decided to investigate whether there were any irregularities in the appointment of senior executive, the executive mayor and council speaker of the city, and whether the former executive mayor misled the public by making pronouncement banning the use of the blue lights and the reconstitution of the mayoral committee and the utilization of the fleet of BMW by members of the mayoral committee. I've thus made the following findings. There were irregularities in the appointment of the senior executives in the offices of the executive mayor and the council speaker. The appointments of Marietta Okamp, Samgelo Mkhwebane, Stefan Andreas de Villiers were irregular as they did not meet the minimum requirements for the positions in which they were appointed, and the city also failed to conduct security vetting on them as required. Although Mr. Babane is suitably qualified and met the requirements for the position, the city failed to conduct security vetting on him before his appointment. The staffing policy makes no provision for the appointment of staff at a senior level on a 6-month temporary contract. I further found that the city failed to implement adequate record-keeping controls, as some of the recruitment documents went missing from the personnel files of the interviewed candidates. The former acting city manager, Ms. Lindy Wekwele, as the accounting officer, also failed to act in the best interest of the city in appointing Ms. Okam, Mr. Mkhwebane, and Mr. de Villiers, as they did not meet the required minimum requirements for the positions and failed to provide guidance and advice on compliance with the staffing policy. She further failed to heed to the advice of legal services in all these appointments. Mr. Shingange, the group head, failed to provide proper guidance and advice to the city regarding the suitability and appointment of Ms. Okam, Mr. Mkobozi, and De Villiers, who were appointed on a 6-month short-term contract and later 5-year fixed contracts. All members of interview and selection panels who participated in the recruitment of the executive head and mayoral committee, mayoral public affairs department in the office of the executive mayor, failed to act in the best interest of the city by not applying their minds to the suitability of candidates regarding their qualifications and experience for the respective positions. The former executive mayor did not apply his mind in the appointment of Ms. Okam because he should have reasonably known that she does not have a post-matric qualification, should have obtained legal advice from his officials on the appropriate way to appoint staff in his office. Instead, he allowed the officials to follow the normal recruitment and selection process, including placing educational requirements and experience that Ms. Okam did not even possess, therefore prejudicing other candidates who were best qualified for the position. I've taken note that the city has taken steps to reverse the irregular appointments of the executive head and mayoral spokesperson, mayoral public affairs department in the office of the executive mayor, as well as the executive head in the office of the speaker. The allegation that the former executive mayor misled the public by making pronouncements banning the use of blue lights in the city and the reconstitution of the mayoral committee and the utilization of the fleet of PWs by members of the mayoral committee is unsubstantiated, in that though public statements were made regarding the use of blue lights in the city, no legislative process was undertaken to amend the bylaws to officially prohibit the use. The allegation that the former executive mayor misled the public is not substantiated. Further, the allegation that as regards misleading the public regarding the use of the BMW fleet is also not substantiated. As part of the remedial action, I directed the city of Tshwane, the city manager of Tshwane to, within 60 working days of the issuance of this report, ensure that a policy is developed to regulate the appointment of staff in the private offices of the executive mayor and speaker, which will make provision for the agent or short-term appointment contracts where a need arises. The said policy should address the job profiles, including requirements for these positions, deviation procedures, and delegations of authority. Within 60 working days of issuing this report, ensure that disciplinary steps are taken against implicated officials in the city who flouted or violated the city staffing policy in this matter. Within 60 working days, develop a document management system that will introduce controls and systems to safeguard the security of documents. Regarding the matter of Mukhatla and another versus Mkhitlane, the Secretary of Parliament, the complaint was lodged on the 18th of July 2016 by the former head of Parliamentary Protection Services, Mr. Mkhatla. Then we had a second complaint which was lodged by Mr. Muchumi, the Deputy Chairperson of NIHAO, which was in July 2016, 20 July 2016. So the complaints were factually similar in nature, and Mr. Muchumi alleged that Mr. Mkhitlane utilized public funds to pay for the travel costs of his spouse to official functions, did not have top security clearance, nor possess the qualifications that he claimed to have, irregularly allowed a junior official to authorize and approve for officials of Parliament to attend a benchmarking study tour to Europe, regularly paid himself an ex gratia payment of 71,000 and irregularly procured the services of an expert consultant, Mr. Mahlangu. Mr. Mkhatla, on the other hand, alleged that Mr. Mkhwebane misused and abused state vehicles, unlawfully suspended Mr. Mkhatla, and irregularly appointed a new SARS official for the Parliamentary Protection Services without following processes. On analysis of the complaint, I decided to investigate whether Mr. Mkhwebane abused his power in performance of his duties and functions, and if so, whether that constitute maladministration, dishonesty, or improper dealing with respect to public money, as well as improper enrichment. I also looked into whether Mr. Mkhwebane allowed a junior official, acting executive manager, strategic management and governance, Mr. Skull, to authorize and approve a benchmarking study tour to England, Scotland, Turkey, Switzerland without the proper delegation authority. I found that Mr. Mkhwebane utilized public funds to pay for the travel costs of his spouse to official functions, which was not regarded as necessary in the interest of Parliament as provided for in their travel policy. The allegation that he did not possess a top security clearance is not substantiated. Mr. Mkhwebane confirmed his security clearance was valid. However, it should be noted that the process depends on state security agents. Also not substantiated was the allegation that Mr. Mkhwebane paid himself an ex gratia amount of 71,000. The allegation that the services of an expert consultant, Mr. Mahlangu, was procured without following supply chain processes is also not substantiated. I found that Mr. Mkhwebane did misuse and abuse PPS vehicles by using the services of PPS for transportation when performing official duties in and around the Western Cape, and in violation of paragraph 8.1 of the reviewed policy on travel, accommodation and subsistence and travel allowance, which was dated 2009. However, I found that the allegation that he made use of blue light sirens used by PPS to transport his family members, that was unsubstantiated. My finding on whether the appointment of SARS officials to PPS was irregular is withheld on the basis that the matter is pending before the Labour Court and that the court's pronouncements in this regard will prevail. Lastly, I found that Mr. Mkhwebane allowed a junior official, Mr. Skulk, to authorize and approve this benchmarking tour to England, Scotland, Turkey, Switzerland without the proper authority, in violation of the financial management of legislation utilized by Parliament. By tacitly condoning her conduct and allowing her to exceed her delegated authority, Mr. Mkhwebane failed to comply with Section 68 of FMPPLA. In light of the above adverse finding against Mr. Mkhwebane and Ms. Skulk, any remedial action I may decide to take against them may not serve as judicious purpose on account of both undergoing disciplinary hearings for findings made against them by the Audit Committee of Parliament on the same allegations. I direct that the reviewed policy on travel, accommodation and subsistence allowance must be reviewed to include, among other things, traveling of the Secretary of Parliament, nationally and internationally accompanied by his spouse or her spouse or companion at the expense of Parliament. The policy must contain proper definition of terms with limitations of the use of words, occasion and official business, and regulate authorization and approval on all international travel, including the Secretary of Parliament. I also direct that a policy provision which regulates the mandatory acquisition of top security clearance for all executive employees must be done within 3 months. I also direct that there be a moratorium on these ex gratia payments. The Executive Authority of Parliament must, within 30 days of receipt of this report, provide me with an action plan indicating the time frames. The next report relates to the Minister Mpumalanga, Office of the Premier. This complaint was lodged by Ms. Nkambule, who alleged that the service provider known as Carol Bauer Productions was irregularly appointed to organize and facilitate the memorial service of the late former President Nelson Mandela. The complaint was based on newspaper articles which were published in the City Press in 16 March 2014. Ms. Nkambule alleged that the newspaper article stated that the Mpumalanga office has spent 70 million, of which 39 million was paid to Carol Bauer Production without following proper procurement procedures. She also alleged that Carol Bauer did not meet the required criteria to be appointed as the service provider of the event, and therefore their appointment was unjustified. Ms. Nkambule further alleged that after payment was effected to Carol Bauer, the Office of the Premier had to shift funds from various provincial departments, service delivery budgets to cover government employee salaries, and this conduct amounted to maladministration. So those are the allegations. Having analyzed the complaint to investigate this matter, whether the Mpumalanga Office of the Premier irregularly appointed Carol Bauer Productions to render the event management services, I also took into account whether the Mpumalanga Office irregularly spent the 70 million. And in this instance, I found that the Mpumalanga Office irregularly appointed Carol Bauer to manage the President Nelson Mandela Memorial Service. Dr. Mkhize, the then accounting officer, failed to report the deviation process in the appointment of Carol Bauer and the amount involved into the provincial treasury and the Auditor General. This is the requirement where she failed in, she violated Section 25(4) of the PFMA and read with various practice notices and the supply chain management policy of the Premier's office. Dr. Mkhize failed to report in terms of section of paragraph 6.1.3 above, rendered the appointment of Carol Bauer irregular and should have been disclosed to the Auditor General. Dr. Mkhize only approved the deviation on the 10th of December 2013 when Carol Bauer had already commenced the work on the 6th of December. This means that compliance with Treasury Regulation 16A 6.4 in appointing Carol Bauer by the office was irregular. The conduct of Dr. Mkhize constitutes improper conduct in this instance. I also found that the 70 million which was spent during the Nelson Mandela Memorial Service was irregular. The total amount paid to other service providers other than Carol Bauer could not be determined as the records I was furnished with were not accurate. The office did not have a supply chain committee in place, so this resulted in the whole amount of 70 million to be an irregular expenditure as required by Section 25(4), that the approved budget should have been reported to the Provincial Treasury and the AG. In addition, Dr. Mkhize contravened Section 38(1)(g) of the PFMA that on discovery of being alerted of the irregular expenditure, she did not immediately report in writing this to the Provincial Treasurer. And another issue was that Dr. Mkhize approved payments to suppliers to be made directly to their bank account without going through the normal logis and bus systems which are utilized to record expenditures and keep records. She also failed to report this, as I've indicated above, to Provincial Treasury and Auditor General. So in this instance, such conduct constitutes improper conduct. The second part of the allegation that the Premier shifted funds for paying employees, which was meant to, in fact, shifted this to pay the service providers, is not substantiated. No evidence was found to substantiate that. So the remedial actions, I have directed the Premier of Mpumalanga to liaise with the Premier of KwaZulu-Natal on the outcome of my investigation and request him to take appropriate action against Dr. Kize within 14 days. I also directed the Director of Priority Crimes Investigation to investigate any alleged criminal conduct against implicated parties for financial mismanagement in violation of the PFMA, specifically the incurring of 4.5 million additional expense not supported by detailed documentation. The DG of Mpumalanga must ensure that officials responsible for procurement of goods and services in the Office of the Premier must at least once annually attend a refresher training workshop on supply chain management, particularly relating to deviations. The DG must also, within 90 days of the report, conduct an investigation in order to determine the total amount paid out to the service providers. The next matter relates to Satao versus Prasa. This is the second part, or second Prasa 2. We call it Prasa 2. The first Prasa was, the volume 1 was issued. So this is the second part. The first part was called Derailed. So the issue regarding the alleged conflict of interest regarding the complaint leveled against Mr. Buthelezi was referred to in volume 1. So we had to investigate where it was alleged that Prasa improperly procured Umjanji House from Transnet without following proper processes, that there was improper payment of salaries made to Prasa's former executive corporate affairs manager. After his resignation, the Prasa made an improper upfront payment to developer for the construction of the underground train station on the Bridge City project. That Prasa improperly awarded CCTV cameras, tendered to Mr. Busisiwe that there was improper engagement of various construction companies in respect of the 2010 World Cup. That the chairperson of Prasa board failed to disclose and manage a conflict of interest arising from the issue of Makana, a company that was alleged to have been associated to Cadiz in this matter, and which that company was responsible for rolling stock and recapitalization project. That Ms. Bushielo was improperly appointed by Prasa as general manager of Autopex. The next complaint was relating to that the former GCEO improperly undertook a blue train trip to Cape Town with 10 female companions to a cost of 170,000, that Mr. Mkhwebane, the erstwhile GCEO cousin, and that he transferred him without taking disciplinary steps against him for alleged appointment of a training contractor. So I found that Prasa improperly procured Umjanji House from Transnet in 2019 without following proper procurement processes and without budget approval. And that the former CEO, in signing the agreement of sale, that was then signed by Transnet representative on the 13th of January 2010 to the sum of 129,500,000, which was purported to have a retrospective effect from 27 March 2009, which conduct is found to be improper. So the contract amount was above the minimum value delegated to the GCEO in terms of Prasa's board delegation of authority, and the process followed is found to be flawed and therefore constitute improper conduct. No approval of the minister regarding the procurement of Umjanji House as required in terms of the of Prasa's delegation of authority policy. And this is flawed and it's improper. The initial payment of 21,500,000, which was made in March 2009 prior to the signing of the agreement, this is an advance payment, is in contravention of the Treasury regulations and is therefore improper. On the basis of the above, I found that the rest of the allegations in this matter were not substantiated. For appropriate remedial action, I direct Minister of Transport to take cognizance of the findings and by Prasa relating to the irregularities mentioned in the report. The Minister must also include in his oversight role as a government shareholder representative with regard to Prasa, monitor the implementation of this remedial action. The chairperson of the board must ensure that Prasa board takes cognizance of the findings and proper conduct referred to in this report, and as well put systems which are compliant to the minimum information security standards, with a view to take corrective actions to prevent a recurrence of improprieties referred to in this report, because we discovered that a lot of records were missing and even the current board couldn't have copies of. The chairperson must also ensure that all acquisition and disposal of significant assets by Prasa complies with the provisions of the delegation of authority and section 54(2)(d) of the PFMA. And that the CEO of Prasa must evaluate the effectiveness of internal controls and systems on the miss with a view to take corrective actions to prevent recurrence of this. Further, the GCEO must also ensure that all staff members are responsible for information security regarding the need to proper management and care of Prasa's records are trained for the entity to comply with the provisions of the National Archives Act. The GCEO must further ensure that the acquisition and disposal of significant assets by Prasa complies with the provisions of the delegation of authority. The offices of the Chief Procurement Officer of the National Treasury and Auditor General must take cognizance of the finding on the irregularities and remedial action mentioned in the report. The next matter is Tshabalala versus Mabuza. Again, this one is the matter which we investigated regarding the irregular procurement of official vehicles for the former Premier of Mpumalanga by the then Mpumalanga Office of the Premier. This was lodged as an executive member's ethics violation, but then it was lodged by the members of the EFF, Mpumalanga, Ms. Amanda Tshabalala. And she lodged the complaint, which already was had taken place in Mpumalanga in prior years, contrary to the requirements of EMIA. So she alleged that the January 2014, the media reported that the Office of the Premier procured 3 luxury vehicles worth 5 million for use by the Premier, one of which was alleged to have been acquired few weeks after the former Minister of Finance, Mr. Gordhan, had presented a budget speech about austerity measures in government. According to Ms. Tshabalala, the 3 vehicles comprised of an Audi 8, a BMW X5, and a Range Rover Vogue. In addition, a Lexus was also purchased to replace an earlier model that was used by the former Premier. The Range Rover cost was 1.9 million, excluding extras, with the Audi and BMW and Lexus costing approximately 1 million each. So the purchase of these vehicles was inconsistent with the provisions of the ministerial handbook. So that's the allegation, because they've exceeded 70% of the inclusive remuneration package of the former Premier at the time. On the same day, the former Premier spokesperson issued a media statement admitting to the procurement of the vehicles. In the statement, Mr. Mwangu, the spokesperson, explained that the vehicles had to be procured due to the former Premier's official vehicles encountering mechanical faults, hindering him from discharging his responsibilities. He also explained that additional vehicles had to be purchased as backup vehicles in the event the former Premier's main vehicle encountered some problems. And he emphasized that the procurement process and procedures were followed in the acquisition of these vehicles, and again that they've complied with the privileges and entitlement pertinent to the former Premier and as envisaged in the ministerial handbook. On analysis of the complaint, I investigated whether the Office of the Premier irregularly procured the official vehicles, the BMW X5, Audi 8, A8, Lexus, and Vogue, and whether the former Premier, Mr. Mabuza, was involved in the procurement of the official vehicles. And if so, whether such conduct constitute violation of the Executive Ethics Code. I found that the Mpumalanga office of the Premier irregularly procured the official vehicles for the former Premier, Mr. David Mabuza. The office of the Premier was precluded from purchasing the BMWs in terms of the ministerial handbook, as it was not an official vehicle of the Premier. So the official of the Premier therefore violated the ministerial handbook. It also failed to procure the BMW in terms of the National Treasury Practice Note 8. Although the A8 was procured through ministerial handbook, the office of the Premier acted contrary to the ministerial handbook, which required to procure vehicles in accordance with the PFMA and its prescript, as found by the AG. The office of the Premier purchased the Range Rover through a deviation from normal procurement processes, but failed to record reasons for the deviation from inviting competitive bids. The AG also found in this regard that the purchase of this vehicle was non-compliant to the RT 16A65, as it was not done according to the contract, the National Treasury contract. So the AG further indicated that the deviation should have been approved by National Treasury. So the AG concluded that the expenditure of the vehicles amounted to an unauthorized and irregular expenditure. Based on the above information, Dr. Mkhize, as the accounting officer in the Office of the Premier, committed financial misconduct in terms of the PFMA during the procurement of these vehicles. The conduct of the Office of the Premier, particularly Dr. Mkhize, constitute improper conduct as envisaged in Section 182. The allegation that the former Premier was involved in the procurement of his official vehicles is not substantiated. The media statements, nature of the complaint, and documentary evidence received by my office indicate that the allegation of irregular appointment of these vehicles was against the office of the Premier and not the former Premier in his personal capacity. No evidence could be found or produced to indicate that the former Premier was involved in the procurement process. There was therefore no violation of the code by the former Premier in procurement of these vehicles. Regarding the remedial action, I direct the Premier of Mpumalanga to, in fact, this one relates to, again, Dr. Mkhize, because Dr. Mkhize is based in KwaZulu-Natal as the DG about this finding. So the Premier further is directs the head of Mpumalanga Treasury to investigate the irregular and unauthorized expenditure. And the head of Department of Mpumalanga Provincial Treasury must, within 60 days from date of this report, ensure that an investigation is conducted into this financial misconduct committed by Dr. Mkhize. The HOD further must also conduct a workshop with heads of departments, CFOs, Chief of Staff, on the provisions of the Ministerial Handbook, Treasury regulations on the procurement of official vehicles to prevent recurrence of these matters and monitor throughout the department. The DG of Mpumalanga Provincial Government must ensure that the officials responsible for procurement of goods and services in the Office of the Premier must at least once annually as well attend a supply chain management refresher course. So the last report relates to the complaint which was received in 2016 around October, is an anonymous complaint which was against the payment of the early retirement with full benefits payment to Mr. Ivan Pillay. So in this particular instance, the report communicates my findings and appropriate remedial actions on the alleged maladministration and impropriety by Minister Godan in his capacity as the erstwhile Minister of Finance in the approval of Mr. Pillay's early retirement with full pension benefits and his subsequent retention at SARS on the recommendation of the Commissioner of SARS, Mr. Oupa Magashula, the then Commissioner of SARS. The complaint was lodged anonymously on the 18th of November 2016, alleging that Minister Godan approved this in his capacity as Minister of Finance. on the recommendation of Mr. Makhashula. Mr. Pilay's application for early retirement and payment of his retirement package. The further payment by SARS of a penalty, in fact this is what we investigated, of 1,141,178, which was levied on Mr. Pilay's pension benefits by the government pension fund, which would allow him to enjoy full pension benefits as though he had retired at a statutory age. Mr. Pilay's subsequent retention as the Deputy Commissioner of SARS on a fixed-term contract basis following the approval of his early retirement. So this is also what we investigated. It is the complainant's contention that Mr. Pillay and Mr. Makhashula, as well as Minister Kodan's conduct, amounted to maladministration in that they failed to prevent SARS from incurring irregular, fruitless and wasteful expenditure in violation of Section 86, right, with Section 1, Section 38 and Section 39 of the PFMA. The complainant also contends that Makhashula and Minister Kodan in essence acted dishonestly with regard to their dealings with public funds, which resulted in Mr. Pillay receiving an improper advantage or being unjustifiably enriched at the expense of the taxpayer. The complainant further contends that the penalty levied by GEPF should be recovered from Mr. Pillay, Makhashula, as well as Minister Kodan, jointly and severally. On analysis of the complaint, the following issue was identified and investigated: whether Mr. Kodan irregularly approved the early retirement of Mr. Ivan Pillay with full pension benefits and his subsequent retention at SARS in the same position. The investigation was conducted by way of correspondence and interviews. An analysis of relevant documents was conducted, consideration and application of relevant laws, related prescripts and case law. Key laws and policies which were taken into account to determine if there is any irregularity in the approval of Mr. Pillay's early retirement with full pension benefits were the following: the relevant provisions of the South African Revenue Services Act 1997, which in essence deems a person employed by SARS to be a person performing part of public service for the purpose of pension and retirement benefits. Relevant provisions of the Public Service Act 1994, which governs the pension rights of employees in public service. The relevant provisions of the GEPF 1996, in fact GEPF, Government Employees Pension Law 1996, and the rules which makes provision for the payment of the pensions and certain benefits. Having considered the evidence uncovered during the investigation against the relevant regulatory framework, I now make the following findings. Regarding whether Minister Kodan irregularly approved the early retirement of Mr. Pillay with full pension benefits and his subsequent retention at SARS in the same position, that allegation is substantiated. Since neither Mr. Pillay's request for early retirement nor Mr. Makhashula's recommendation to Minister Kodan contemplated retirement, there was no retirement in fact and in law. If there was no retirement in fact and in law, it can be concluded that Mr. Pillay was not entitled to early retirement with full pension benefits under any statutory provisions. Even if retirement had been contemplated and there was in fact a retirement, Minister Kodan was not authorized by Section 16(2) A of the PSA to approve Mr. Pillay's early retirement request with full pension benefits, as this section does not confer any power on the minister to approve early retirement with full pension benefits. Mr. Pillay was not entitled to an early retirement with full pension benefits under Section 16(2) A of the PSA Act, the Public Service Act, because the section makes no provision for such full retirement benefits. Section 16.2, capital A of the PSA only confers a right on an employee to retire from the public service upon reaching the age of 55 years. In terms of this section, no ministerial approval needs to be sought. Even if the request by Mr. Pillay for early retirement had been sought under section 16.6, where Minister Godane would not have also, in fact, Minister Godane would not also have been authorized to do that, to approve Mr. Pillay's pension benefits, because the benefits to which an employee is entitled to on early retirement are regulated by this section and occur by operation of the law. So there's no ministerial approval which is required. Minister Godane's conduct violated, in fact, was amounted to an improper conduct. So when Mr. Makhashula made recommendation to Minister Godane for the approval of the early retirement without downscaling of his retirement or pension benefits, SARS, through Mr. Makhashula, took action which is contemplated in the GEPF law, thereby triggering additional liability to GEPF. And the payment of this additional liability by SARS amounted to irregular expenditure, as envisaged in terms of Section 38 of the PFMA. Mr. Godane also acted ultra vires in approving the retention of Mr. Pillay, as Minister Godane was not authorized by law to do that. I'm taking the following remedial action. The President to take note of the findings in this report insofar as they relate to the erstwhile Minister of Finance, Mr. Godane, to take appropriate disciplinary action against him for violating the Constitution. And the Commissioner of SARS to set in motion steps to recover the money paid, actuarial deficit, or penalty on behalf of Mr. Pillay by SARS to GEPF from the ex-while Commissioner of SARS, Mr. Makhashula, and to ensure that SARS introduces part of their recruitment processes, regulations, policies, and practices which are clear and unambiguous relating to early retirement and staff retention. Okay, thank you so much for listening. Mr. Sekhalu.
Thank you, Public Protector. We are now going to open the floor for questions. We will take them in batches of 3 or 4 at a time, and we will request all of those who will be posing questions to the panel to introduce themselves, indicate which media house they represent, and then put their questions across to the panel. I noticed just one hand up to so okay, there's 2. And then the third one, that side of the room. Let's do it in that order. First the lady here and the gentleman behind her, and then
Good afternoon, Public Protector. It's Genevieve from the Business Day. First thing, I've got 3 questions. In your findings or in your remedial action, you asked the President to take action against Mr. Godane for violating the Constitution. And I'm sorry if I don't understand. In your explanation before, it doesn't mention the Constitution. So I just want to understand whether violating the Constitution comes in there in terms of the reasons given before that. I don't know if I've misunderstood something there. Also, you spoke earlier about the Field Dairy Farm matter and all that, and we can be probably quite sure that this matter on the early retirement will go to court. Are you ready for that? For that to go to court? Are you ready to stand up to this report? In the Field Dairy Farm investigation, there was an issue of, or the court had accused you of ignoring information that's out there in public, such as the Gupta leaks. In this one, there was a legal opinion on this. The NPA had, yes, they brought charges, but they withdrew the charges. Has all of that been taken into consideration? And then secondly, I think a lot of people are wondering why the rush to get this out. I know you say that it's not politically motivated, but we do have a cabinet announcement coming in a few days. And why the rush on this? Thanks.
Greetings, my name is Zengisa from the Sunday Times. My first question would be to ride with my colleagues' last question with regards to the timing, and not only relating to the finding against Mr. Gordon, but also to the reports on Mr. David Mabuza, who is currently the president of the ANC, and the political situation surrounding that at this time. And secondly, with regards to the reports on Mr. Mabuza, the two, doesn't he supposed to have known as a political leader? I know you made adverse findings against the office of the premier when he was premier in Mpumalanga, but you cleared him in both. Doesn't he ought to have known as the political head of that particular office? Thank you very much.
Thank you. My name is Belane Pachadi. I'm from Newsroom Africa. Okay, just one about the DA wanting already written to Parliament for your removal, and of course with the two court outcomes which seem to be against you. Are you confident that you are perhaps doing your job correctly? Or is there something that you think you should go back to the writing board and to take a look? And secondly, yes, I just wanted to also to just show, go back to the steps of my friends there. Why the timing now of this particular report, especially looking at the Gordon matter?
Okay. Business Day, your question relates to the violation of the Constitution. Ministers are appointed to uphold the Constitution. I think you know in terms of Section 95 of the Constitution, you'll get it in the report. Ministers are supposed to be obedient to the Constitution. And when we deliberate more on the payment of the pension and the retention immediately of Mr. Pillay, we also dwell into other sections of the Constitution relating to issues of transparency, the issues of also the issue of perceived preferential treatment to this one individual. So yes, going to court, it's a right of every person who has been investigated to take the matter to court for review. And even in this particular instance, we will try our level best to defend ourselves. On the Friede Dairy matter, apparently if that I've ignored information. When I investigate as a public protector, I determine what happened, what should have happened, what are the prescripts which have been violated, and what is the way forward, or what we need to redress. I think you know that this matter was investigated by my predecessor. It was the investigation was complete in 2015, though then when I joined the institution was to check all the evidence which we are having and finalize the investigation. Therefore, the issue of the Gupta leaks have indicated and addressed in the matter that we've received those, but we don't deal with that information which already there is, veracity is also not yet tested. We deal with the information which is before us, and after receiving that information, we need to interview any person who's drafted any document. So it's evidence-based. We don't just rely on what is written on the media or on information out there, but then it's evidence-based. And I indicated that we've referred those information because it falls squarely within the terms of reference of the State Capture Commission, the very same State Capture Commission which was established as a result of the Public Protector Remedial Action. And that the NPA brought charges, again, we've explained I don't know how many times. It's so unfortunate that You know, when we place our information before some of the media houses, it's not published fully and completely so that there's a factual reporting. We've been saying the Pulp Protector, you all know, is a Chapter 9 institution. The mandate is totally different to what the NPA is doing, which is part of the Department of Justice. They focus on criminal conduct of each person. We focus on maladministration. And remember, the Pulp Protector, again, to support constitutional democracy. Whatever action we found to be improper, we need to correct it. We need to prevent the recurrence of that. Whereas the NPA's mandate it's like investigating a crime, and the person will be found guilty, either fined or serve imprisonment. Well, the issue of corrections is something else. But the Pulp Protector, we're focusing on good governance and clean governance. So in this particular instance, I mean, you know that the NPA or even the courts have withdrawn certain charges against these people. But from our side, we have done our work. We are making sure with that report that if you are an HOD of agriculture and there is a project like this is how you need to behave going forward. So, and you know that now we are investigating the role of the politicians and the benefits or the prejudice to the complainants. And when you say why the rush, I mean, now it means the Pulp Protector must not issue reports because whatever is happening around the country, as if now I must do my work without fear or favor or prejudice. Why must events dictate how I must do my work? But again, remember I said almost all these reports. This report was launched November 2016. In terms of our APP, we need to make sure that all cases older than 2 years must have been actually finalized by 31 March. Actually, we even when we're going to report on our activities to Parliament, we need to account because we've said we need to finalize those cases. So these cases, all of them are 2 years cases, including this one of Mandela. If you would know that we've even sent that report out a week or 2 weeks ago. We didn't even know that these were going to be issues. And the investigation and the evidence we're having, these matters were brought to the attention of the Premier. The complaint was lodged, the violation of the prescripts, and the PFMA puts every responsibility to the accounting officer. He did not know because the accounting officer procured the vehicles based on what the needs of the Premier's office. Actually, the vehicle which we are saying was procured to be utilized as a pool vehicle, not even to be used by the Premier. So this is an administrative process which the political head is not even involved in the operations of the institution. So we have that information. So the timing on both issues, I think for me, we need to issue these reports. So the next question about the DA removal. We have issued more than 50 reports now. And as I said, most of them are backlog matters where, as an institution, we were even, not finalizing our investigations speedily, and also committing the very same undue delay in these matters. So I don't understand well their need to do this, and I have already posted, or we've posted in our social media and even in our website, my response or comprehensive response to Parliament last year when they tried to remove me. Well, it's a political act which they are busy with. And I know in the first place, remember, they never supported my appointment. So the drawing board, we always go back to the drawing board. We prepare our reports. We've got the COO who's responsible for investigations now. We make sure that our reports are quality assured and all the prescripts are followed. It's so unfortunate that sometimes we can't have control on the intentions of certain individuals or political parties to take our reports to court so that the courts can also make certain pronouncements which will be regarded as if one is not doing or performing her work competently. So I think I'll end there.
Thank you, Public Protector. Are there any more questions, colleagues? Okay. There's a follow-up from the Sunday Times. I see. Is it open news?
No, it's
ENCA. Yes. It starts here and then you go.
So this again from Sunday Times. Mkhwebane, what in your own analysis is the reason for the growing anti-sentiments against you and the cause for your head, like a comprehensive analysis and your finding with regards to that public sentiment that is growing, and who do you think is driving it, if you have any idea at all? And then secondly, with regards to issues of budgets in the office, you know, the office has, you know, most of the time, even before you complained with regards to budgetary constraints, where are you standing right now? And you have, you know, in terms of your legal budget money to defend yourself, should any of the parties found against you, they take you to court? Thank you.
John Bailey, ENCA. Mr. Public Protector, just if you can comment again on the issue of the ruling by the Pretoria High Court that your Freedom Dairy Farm report was invalid and unconstitutional. Thank you.
Thank you. I'll start with the Sunday Times. The growing sentiments about this. As I've indicated that MiniDA never supported my appointment. They've been going around finding or trying to find any reason for my removal. And unfortunately, now they will also be using the courts to do that, having frivolous litigation. And I think by lodging those legal challenges, we wouldn't just keep quiet and not defend them because of allegations that we don't have a budget. And then we need to make sure that whatever, because there are precedences which courts set up, as I've indicated earlier, that case law is sometimes referred to. Therefore, by defending the matter, mostly is also to put our side of the story. And so that the courts, when they decide, they determine both sides. Therefore, again, as the Public Protector, I do have the right to appeal any decision which I find not to be in compliance with the prescripts of the law. So, defending the matter, we are using our goods and services budget, and with planning and with proper allocation of funds, we have the CEO who will also make sure that we allocate our funds properly. That is happening. The worrisome issue which I indicated when I was issuing those reports for name and shame was that you find reports or remedial actions which we've taken affecting people at the grassroots, where you'll expect organizations like Bokasak and them to come forward and make sure that those remedial actions are implemented to benefit the people at the grassroots. But now it's so unfortunate that then there is the focus on certain politicians or on certain high-class individuals to fight this. But the fact of the matter is possibly, I don't know when you say they're growing, because you know, people who are on Twitter and on Facebook compared to people whom I'm servicing as a public protector are totally different. When we as South Africans, we will now take whatever Twitter is saying by a certain organization. It's worrisome. And so I'll just end it there. And the ruling by the court, Mr. Bailey, we will appeal the judgment, that's for sure, because the judge also applied, in fact, didn't also consider, especially the Supreme Court of Appeal judgment, because public protector's functions, when I do my work, I'm not compelled to do my work within the budget, which is the Public Administration and Justice Act. So that's what the application was relying on. So we will appeal the matter. I'm still going to meet with the legal team to decide whether we only appeal or then also we take the route of approaching the Constitutional Court directly. So if we, again Sunday Times, the public protector is here for the public because the public cannot litigate. So we make sure that South Africans or the ordinary people can access justice. I think that is our main aim. So it's so unfortunate that if they take the public protector to court and set aside the report, it impacts on the very same people we are trying to protect. I mean, this freedom matter, if it's set aside, and already Free State has implemented that report, so it means then those people who have been found to have acted improperly, they can come back and say, you need to re-employ us because, I mean, the court has set aside that public protector report. So, and I think that it will be promoting another maladministration, which, I mean, we know that where there's maladministration is a fertile ground for corruption. Thank you.
Thank you, Public Protector. I see there's two more questions, and I take it this is going to be the last round, colleague. So, apart from the two gentlemen, is there anybody else who still wants to pose a question? Okay, thank you. Let's start with.
Good afternoon. It's Alex from News 24. This is just on my colleague from Business Day. She did ask whether you took certain things into consideration with the Gordon finding. She mentioned the NPA. She also mentioned the legal opinion that they received, and you didn't answer on that. So if I can just specifically ask, did you take the legal opinion into consideration? And you obviously found that you obviously found against the legal opinion that they obtained as well. Then, thank you. Yeah.
Ms. Public Protector, just concerning the Gordon issue that he acted unconstitutionally, could this have an impact on the newly appointed or the cabinet that still has to be appointed, especially if Mr. Gordon is part of that cabinet?
Thank you. The News 24 article, the report will be available on on our website, the full report. The full report is having all the interviews we had. We remember we subpoenaed Minister Kodan, Mr. Mahashule, Mr. Pillay, Mr. Flock Symington, Ms. Suzanne Hendricks. We also subpoenaed Michael Olivier. We also wrote to GEPF, the CEO of GPF. We got information. We also wrote to Public Service and Administration, especially on allegations that this has been done or certain employees also took pension with full benefits and were reinstated. In fact, we were checking, comparing apples to apples, but I think most of the evidence we are having is that you take your retirement, and if it's with full benefit, but you are not reinstated immediately, so it's not the same, or you take your retirement, but you are penalized as an employee, not to say the department or the government will pay. So you will read the report and then you will see what arguments we've used in this matter. Again, as I said to you, we check what happened, what should have happened, what are the prescripts which have been violated. If you can check, we focused on the prescripts which have been violated in this particular instance, but then taking the facts into consideration. This was done, this person, was there any preferential treatment? Was there any way of treating this person differently to other employees who requested that? And are the facts similar? So it's very detailed in that particular aspect. And the impact of this matter, again, Mr. Bailey, I'm saying to you, I'm issuing this report because it's a matter which is 2 years and old. And secondly, it's up to the president, who is a constitutional being. I don't know whether it will have an impact, but remember, ministers and all the MPs take an oath or an affirmation to abide by the laws of the country and the constitution. Therefore, I wouldn't dictate to what action the president will take. Possibly will determine. I can't indicate on that. Thanks.
Thank you, Public Protector. On that note, I will end this press conference. Thank you so much to the colleagues for the attendance and the participation. Thank you.
Can I have one?
I think I jumped this part. Why don't you?
It's going to be like
Okay.
and what we need to focus on.
You don't want to.
For me, it's the
You don't want to just the correction there. But anyway, the report is there. This is just a.